paper, so I put it down there. But from our experience, from our practical experience, we find that there are so many different solutions and alternatives that we, in our network, we have a stand that says that this is just not needed and this is hazardous as a technology in itself. This is not about an argument which says that if you regulate it better, the technology will become safer. It's not like that. We are saying that there are fundamental problems with the technologies and the hazards that flow from the technology per se, the process of genetic engineering per se, and therefore regulation is needed. We don't believe that better regulation will make the technology safer. Some of us do that, but I respect your school of thinking if you think that let's not close the doors on this being an option.
And please, we're in a room full of lawyers. You talked about monitoring, compensation, penalties. What about liability? Who is responsible? Who will penalize?
It will come.
Absolute liability, burden of proof, orders of proof, what should be comes out of
liability, promise of proof. And since we are talking about an environmental issue, there's an element of remediation also probably required, because it's not enough that you're penalizing someone and making someone liable, but within that liability we have to articulate the fact that if cleaning up is needed, if restoring something to its original state is required, there is an sorry? Revocation, if approvals are given. Hopefully, no approvals will, be given if they pass through this whole thing. Okay, revocation. Then?
Strict conservation standards.
Strict what standards?
Conservation standards.
Which you would agree should be the beginning point. The entire reason for regulating should center around this and to protect health and things like that.
Proper import and export.
You're saying that regulation should cover that also.
Yeah, if there is export or import, it has to be.
So it's a regulation of marketing, import, export, storage, all these things. That it should ideally cover all these operations.
Labeling also. Identify.
If it comes in.
Yeah.
The green legislation should ideally prevent all these things. Revocation, labeling and so on. Because if it's true that the technology itself is hazardous, somewhere or the other you should be able to catch those early warnings, and the precautionary approach requires you to say no, right? So one should not even be reaching those stages of saying that we'll allow it, then label it and so on.
No, it's a big if no, so we have to...
No, but I agree, these are all components of,
Please, what's the objective of an election? Not to pass it or to set the standard for it?
No, you tell me, what should it be? You have heard a presentation on what is genetic engineering and what kind of evidence already exists which shows health and environmental risk. If that's the case, I think it's a very important question that you ask because...
It's open to research, so we should not close the door there only.
Right.
Let the researchers do their work.
Right.
Very hard testing standards for that.
So,
for 20 to 30 years it should be tested in a conserved environment, not open pollination or something like that. And if it approves your standard, it should be legal.
So a law that clearly recognizes a contained use for research purposes and if needed, including those things about are there no other alternatives and so on, you're talking about something that clearly distinguishes between these two, right? Yeah. Anything else?
Proper environmental assessment, environmental
testing includes environmental impacts, and what else do you think it should? And what else?
Mode of research.
What does that mean?
Mode of research.
What does mode of research mean?
What type of research he is doing?
Under testing. Are you rushed for time? Because you could easily take over from here. What we've done just now is it's a group of lawyers. What we've done is, what would your dream legislation around regulating GM would be? And several core elements are coming. Probably you should just pick up from here and say what's happening right now.
Why don't you go ahead?
Because my slotted presentation is on the NBRA proposals, and you can speak about the current. Okay, let me introduce you to Mr. Prashant Bhushan. You would all have heard his name. Probably no more introduction required than that. So we had listed all these things already.
No, I think Kavita has done me a great favor by listing all the aspects which are relevant in this regulation of genetically modified organisms.
So, one thing is lacking, I think impact on future generation.
I think multi-generational equity.
Well, no, that's let me differentiate between.
I just add it here. Please do differentiate.
You don't have to, actually. I'll tell you why. You see, impact on future generations is one of the problems of genetically modified organisms which needs to be studied. One of the potential problems of genetically modified organisms which need to be studied. There are many. In fact, one of our complaints before the Supreme Court in this petition that we have filed in the Supreme Court regarding regulatory systems for genetically modified organisms is, we have said that if a regulatory body were to examine a particular genetically modified organism for its biosafety, it will first need to have an understanding of what its potential effects could be, potentially harmful effects could be. Firstly, what is this genetically, how is it being created, and then, therefore, according to our current understanding of science, of biology, agriculture, etc., and ecology, what are the potentially hazardous influences of this particular genetically modified organism? One of them, as we now understand, is that even if it does not show any immediate effect on those people who consume that or who are exposed to that genetically modified organism, it could show an effect on the future generations. This is one of the potential hazards of genetically modified foods or genetically modified organisms. When we went to the Supreme Court, actually this petition will illustrate most of these issues. 5 years ago, we filed a petition in the Supreme Court, which is called Aruna Rodriguez versus Union of India, in which we said that this whole regime for the regulation of genetically modified organisms in the country under the Environment Protection Act and under these rules which have been made for hazardous microorganisms and genetically modified organisms, this regime is still too lax. It's lax, it's non-transparent, it does not allow any independent scientist to participate in this process, and it doesn't lay down the in these rules, they have not laid down what are the steps through which the regulatory authority needs to proceed before deciding that a particular genetically modified organism must be cleared for release into the environment. You must have already been told in the morning session, I am sure, that genetically modified organisms have various serious potential problems, and the important thing to note about them is that these are self-replicating organisms which can also interbreed with other related species and therefore also contaminate other related species. Because they are self-replicating organisms, particularly of these genetically modified agricultural products, there are also genetically modified medicines which are in a slightly different category, which need not be self-replicating. But these are agricultural organisms which, if you release into the environment, foods, etc., they will continue to replicate, continue to proliferate. They will crossbreed with other related species. So, for example, if you have BT brinjal will crossbreed with all the various varieties of brinjal and therefore contaminate all the indigenous varieties of brinjal, because the bees and the butterflies and so on will sit on BT brinjal and they will cross-pollinate the normal brinjal. So, we said that since these are hazardous self-replicating species and therefore the release into the environment needs to be done only after you have ascertained that they are safe, that their biosafety has been determined, only then you can release them into the environment. That's what is envisaged even under these rules. Under the Environment Protection Act, they have made rules for hazardous microorganisms and genetically modified organisms. So therefore they are treated as hazardous, and that is why a regulatory body called the Genetic Engineering Approval Committee has been set up in order to regulate the release into the environment of these organisms. But what we said was, these rules, while they say that GAC will determine or will decide whether to release them or not, they don't say what are the steps that the GAC has to take in order to test these organisms for biosafety. So we said that any rational process of testing organisms for biosafety will require at least two stages. In the first stage, you lay down a series of tests that need to be done in order to see whether they are safe or not. That means you need to have an understanding of what the organism is, what it would do to other species, to soil microorganisms, to the environment in general, to human health, to animal health, etc. And depending upon that, you need to first lay down the kind of tests, biosafety tests that need to be done. Before finalizing these tests, you must have some public consultation in which independent scientists should also be able to participate, so that independent scientists can also tell you that look, this can also pose this particular hazard, that it can in fact affect future generations, and therefore multi-generational feeding trials have to be done in order to test for their biosafety. So, first step, to lay down what tests need to be done, and that has to be done with full transparency and giving an opportunity to independent scientists to critique the list of tests which the regulatory body has tentatively laid down, so that the number of tests which need to be done or the kind of tests that need to be done can be decided after this public consultation with independent scientists. This is the first thing. Dr. P.M. Bhargav, who is one of the leading geneticists or biological scientists in this country, who set up the Center for Cellular and Molecular Biology in Hyderabad, which is the best scientific institution in this field in the country. He was finally inducted into this as an observer or as an invitee into this GAC about 1 year ago by the Supreme Court, on the orders of the Supreme Court. And for the first time, an independent scientist was able to see what was going on within the GAC, how they were proceeding to decide whether a particular genetically modified organism should be cleared for release into the environment or not. And what he found was that firstly, the GAC was not getting any tests conducted by any independent research institution. They were only asking this very company, for example, if Monsanto is the company which comes for getting clearance for BT brinjal, they were asking only Monsanto to do some tests, or essentially Monsanto to do some tests, and then report the results of those tests to the GAC. And they were only asking them to do only 4 or 5 tests. For example, they were not testing for they were not doing any multi-generational feeding studies. They were not testing for what is called chronic toxicity, they were only testing acute toxicity, which means, toxicity can be of two kinds. Means that kind of toxicity whose effects are immediately felt. If you eat it, you get poisoning, some kind of food poisoning, and immediately you can experience the effect of that toxicity. The other is, for example, we all know that one of the major causes of cancer is the fact that we are all eating pesticide-laden foods. That is, pesticide which is sprayed on all kinds of vegetables and fruits, etc. Some residue of that remains in that fruit and vegetable even after washing it, and that causes what is called chronic toxicity, which means that the effects of that toxicity are not immediately felt, but they are felt over a period of several years. After you've been eating that pesticide-laden food for several years, then you might develop cancer. So, they were not doing any such tests to test for chronic toxicity. They were not doing any proper tests to test for allergies. They were not even determining. What he found was that they were in fact testing with a protein which had been manufactured in an entirely different way. They were not even testing the actual BT crop that they were growing. They were testing on a surrogate protein.
An artificially produced.
Artificially produced protein of a similar kind, but which has several different properties. Therefore, if you test on that surrogate protein, because that was easy to manufacture, that could be manufactured through a bacteria, etc. Manufacturing this and testing on this involved a little more effort, so they said, no, surrogate protein is good enough, it is equivalent, and therefore we will test on this surrogate protein. Many large number of independent scientists pointed out that the surrogate protein is completely different. It has many different properties, it can have different effects, and therefore you need to test on the original protein. They were not even doing a full proteomics study, which means the range of proteins that exist within that genetically modified food or organisms. They were not even doing that whole assay to find out what are the various proteins which are present in that. So therefore, all kinds of tests. Dr. Bhargav pointed out that at least 29 tests need to be done, even for BT brinjal, at least 29. And out of that, they were doing only 4 or 5 tests, and those tests too were being done in the laboratory of this company. And the company was just sending some results to the government, to the GAC, and the GAC people were not even bothering to examine the results, not even bothering to examine the raw data, and they were just simply accepting the conclusions of the company. If the company said that, look, this test shows that there is no acute toxicity, they would just blindly accept that without examining even the raw data. In fact, Dr. Bhargav once in one particular case saw that non-BT brinjal was being shown by the company to have the BT protein. That showed that the tests were either being very carelessly done or the results were just being doctored. And the GAC was not even bothering to examine that. The result was that in this whole regulatory process, not only was the GAC not consulting the people and the independent scientists about what tests need to be done, they were also allowing this company to do the test. A company which has an interest, a commercial interest in getting approval, and therefore they have an interest in showing that this has no adverse effects. They were allowing this company to do the test, not even examining the results shown by the company, and giving approval only on the basis of that. That's what he found. So even on this particular aspect of testing, monitoring, the first question is, should we not have a system which is transparent, where the kind of tests that they are asking to be done are put out for public information, for critique by independent scientists, that whatever tests are done, that their results are put out again for public information so that independent scientists could critique those tests. Actually, we had to fight for a long time in the court in order to get Monsanto to even disclose the data, in order to get the GAC to even disclose the data that Monsanto had given the GAC about some of the tests on BT brinjal regarding toxicity and some aspect of allergenicity. When those results were put out on their website after a great deal of effort and on the orders of the court, what we found was, when they were studied by independent scientists, very, very competent independent scientists, they found that these tests actually do not show anything. Certainly you cannot say on the basis of these tests that this has no toxicity or allergenicity, but yet they were claiming that. So this is so far as the testing regime is concerned. So we have been saying, so far this issue has not yet been decided by the Supreme Court. It is still pending in the Supreme Court. That is, they're ordering what kind of systems have to be put in place to ensure transparency, to ensure public participation by independent scientists, etc. The other aspect was that GAC should not have any conflicts of interest. That is, you can't have a regulatory body which is itself receiving, where people are in that regulatory body are themselves connected with in some way, or receiving funds in some way, or receiving any kinds of benefits from those companies which are coming to them for approval. If you have that situation, naturally the members of the GAC will try and give a favorable report and do whatever that company wants. What we found was that there were various kinds of conflicts of interest within the GAC. The first was, there was a problem of incompetence and there was a problem of conflict of interest. The GAC is headed by some joint secretary in the Ministry of Environment. Usually he is a person who doesn't know anything about this technology. Second problem was, we found that the co-chairman of the GAC was a secretary from the Department of Biotechnology. Was he secretary or additional
He
secretary?
was from AS Agricultural Scientist Recruitment Board,
Achha.
but on that ISAAA, he's a director.
Yeah, right. This gentleman called C.D. Mai, he was a scientist, or at least, he had got a degree in this field. But we found that he was also on the board of an organization called ISAAA, that is International Services for the Acquisition of Agro-Biotech Applications, something like this. Anyway, this is an organization which has been set up. It's a front organization of these biotech companies like Monsanto, etc., which was set up by them for the purpose of their stated agenda is to promote these genetically modified organisms and genetically modified foods in the world, particularly in third world countries. That's their agenda. This organization is funded by the biotech companies like Monsanto, DuPont, Dow Chemicals, etc. It's also controlled by these biotech companies who run it for this very purpose. And the co-chairman of this regulatory body, the GAC, happened to be on the board of directors of this organization. Not only the co-chairman, even Mr. M.S. Swaminathan, the so-called father of the Green Revolution in India and the so-called greatest agricultural scientist in this country, he was also a patron of this very organization, ISAAA. And you might have seen some articles by Mr. Swaminathan recently, basically promoting genetically modified foods as a way for the third green revolution. Actually, this is the pitch that is being made by the government, by even people like Mr. Swaminathan, that we need this for a third green revolution in this country, or a second green revolution in this country, or whatever. That the first green revolution has run its course, now there are diminishing returns. Now in order to start another revolution, we need genetically modified foods. And the people who are saying this are mostly people who are directly or indirectly receiving some benefits from these very biotech companies who have patents on these genetically modified foods, who have a commercial interest in that. So, conflict of interest is a very, very important issue, that we must have a regulatory body which has no direct or indirect conflict of interest. The other conflict of interest that we saw was that this body is supposed to, government keeps saying that it has 10 independent scientists. Now, who are these 10 independent scientists? They are mostly scientists who work under some lab or something of the Department of Biotechnology, firstly. Department of Biotechnology is the department of the government who think that their job is to promote this biotechnology and therefore genetically modified foods, etc. They feel that it is their duty to push for this. So this is the first level of conflict of interest, that is, these are all scientists who are receiving their salaries from the Department of Biotechnology, or most directly or indirectly. The second is, many of them are working in these agricultural universities, etc., where either they or their universities are receiving grants from companies like Monsanto. For example, the Tamil Nadu Agricultural University, which has become, or many of these agricultural universities have become great supporters of this genetically modified foods. Most of them are receiving large funds or substantial funds from companies like Monsanto for carrying out some experiment or the other. In fact, in West Bengal, it was found that some of these scientists in the agricultural university there were being sent checks by Monsanto without doing any work. They were supposed to be, theoretically, they were supposed to be supervising some field trials that this Monsanto was conducting or that their university was supposed to be conducting, but they had no knowledge of that, and they found that they were receiving checks from Monsanto. So, today in this country, in fact, this has become a very, very serious problem of conflicts of interest, because just as large number of people are directly bribed, of course we don't know how many people in this GAC were bribed directly by Monsanto for getting approval of this BT brinjal, because